In a premises liability case, a plaintiff generally must prove that the defendant had actual or constructive knowledge of a dangerous condition on the defendant's premises that caused the plaintiff's injury. But how can the plaintiff prove constructive knowledge? The Georgia Court of Appeals considered this question in Wallace v. Wal-Mart Stores Incorporated. In the early 2000s, Karen Wallace and her husband went to a Wal-Mart store in Georgia to buy frozen okra and butterbeans. As Wallace walked through the store's produce section, she slipped on a grape and fell, causing her to break her hip and injure her back. Her husband yelled for help, and an employee and co-manager came to the scene and called for an ambulance. Subsequently, Wallace sued Wal-Mart in state superior court for negligence. During discovery, the employee was deposed and testified that she was stocking produce in the salad section when Wallace fell, and she didn't see a grape on the floor until after the ambulance arrived. Also, a second employee was deposed and testified that he and the first employee were walking toward the produce section when Wallace fell, and he saw the grape on the floor. In addition, the co-manager was deposed and testified that Wallace's husband told him Wallace had slipped on a grape and fell, and he remembered seeing the grape on the floor. Further, the co-manager stated that his employees told him they'd been through the area 15 to 20 minutes before Wallace slipped and fell, but hadn't noticed a grape on the floor. Finally, Wallace's husband was deposed and stated that after the co-manager arrived, an employee put her foot over the grape, and the co-manager told her to get her foot off it. Following discovery, Wal-Mart moved for summary judgment, which the court granted. Wallace appealed to the Georgia Court of Appeals.